Hi, I'm Alec Davie and I'm here with my colleague Samuel Mulligan. We're both solicitors in the dispute resolution team at Whitehead Monkton. We both specialise in civil litigation and within this have expertise in both residential and commercial disputes. So Sam, over the last couple of years, there's been a lot of talk in the press about commercial landlords finding it difficult to recover unpaid rent after the pandemic began to affect the UK. What options are currently available to a commercial landlord to recover rent arrears if a tenant will not pay its rent as it falls due?
Well, thanks, Alec. I think some options do exist for landlords as it stands at the moment. The first option that a landlord can look to is to pursue a straightforward money claim in the county court. However, that can be a slow process as the courts have quite a backlog of cases to work through as a result of the pandemic and due to remote working arrangements. Whilst we are seeing signs that the situation is improving in some courts, it's still the case that a money claim can become a protracted dispute and it may not result in an immediate payment. The second option for a landlord is to pursue a guarantor of the tenant's obligations under the lease. And this can be an effective means of recovering the rent arrears. So it is therefore worthwhile checking the lease to see whether there is a guarantor and considering whether they're likely to be in a position to make payment. Unfortunately, even if there is a guarantor, they may not always be able to settle the arrears, but it is generally preferable to pursue more than one person if you can. The third option that a landlord can pursue is to pursue a former tenant or guarantor. And the options for doing so will depend on whether the lease is what's known as an old lease or a new lease. And the key date here is the 1st of January 1996. There is a notice procedure that applies which has strict time limits, so it's important to talk to a solicitor early if this is an option that is being considered. Furthermore, if payment is made, this can result in the former tenant or guarantor taking an overriding lease of the premises, so this will need to be carefully considered. The fourth and final option for landlords at the moment is to draw down funds from a rent deposit as a short-term means of covering the outstanding rent and then demand that the tenant tops up the rent deposit to the minimum level stated in the rent deposit deed. However, the disadvantage of this option is that tenants have been slow to then top up the rent deposit, leaving landlords exposed in respect of future claims that may need to be made on that deposit.
Are landlords still struggling to recover unpaid rent from their tenants, or are there signs that things are improving for landlords in the prospects of recovery?
Yes, as a result of the general opening up of the economy over the summer, a lot of tenants are now in a better position than what they were, Alec. Therefore, the majority of tenants will have either settled outstanding arrears or legal proceedings will have been commenced in respect of the disputed arrears. Indeed, in some cases, summary judgment will have already been obtained on the arrears, or alternatively, there may be ongoing disputes between the parties. One thing I would say is that, quite understandably, tenants are keen to extract themselves from what are now seen as onerous leases, which were negotiated in the period before the pandemic commenced. We're therefore seeing more and more tenants seeking to serve break notices as a result, and also tenants are becoming more forthright in the terms that they're seeking in respect of lease renewals. So by way of example, tenants are expecting to see improved rent suspension clauses in the event of future lockdowns, and they're also looking at options to keep rent in check, particularly if there are rent review mechanisms in the lease which are linked to inflation, such as RPI. Now, Alec, I wonder whether you could tell us a bit more about what we can expect to see in 2022 in this area.
So initially, the government has introduced a commercial rent coronavirus bill. It was introduced to Parliament on the 9th of November 2021, and this seeks to establish a legally binding arbitration process to settle disagreements. While the government's guidance so far hasn't given any outright waiver for tenants to not pay their rent, they have provided some guidance to landlords to take a reasonable approach to their requests for rent. So this guidance creates a level of uncertainty that will no doubt create numerous disputes in the coming months as the pandemic seems to be coming to an end and restrictions seem to be loosened. This arbitration will no doubt become helpful then in creating a procedure that landlords and tenants can seek to resolve any dispute surrounding rental arrears.
Thanks, Alec. That does sound very helpful, particularly for landlords and tenants. So will the arbitration process be binding on the parties?
Yes, it will. They are seeking to make it binding, so that it should be a shorter procedure than going through the court process and waiting for a binding judgment from the county court. Then moving away from the arbitration, there are further measures that will be added in 2022, such as statutory demands that continued to be restricted. The restrictions were initially due to expire in September. However, they will now be extended until March unless there's further guidance from the government that says otherwise. Landlords should note, however, that even though they can't pursue rental arrears through statutory demands, there are other funds such as service charge, maintenance costs and insurance that can be sought through this method. However, the sum would have to be over £10,000. And then lastly, on the 25th of March 2022, landlords will be able to pursue forfeiture once again against tenants that are unable to pay their rent when it falls due.
Thanks, Alec. If landlords are facing an issue with